Teresa Phillips here from Forrester Bowman. I'm excited about today's presentation because we're wrapping up a series that we've done here the last couple months, trying to explore a little bit more about what Florida law protections are in place for the elderly community who is subject to financial exploitation and other kind of abuses. And today we get to kind of circle back and see how far we've come, what the trends are in the laws and the trends in the policies, and educate ourselves more on the resources available and what we can do to prevent elderly exploitation. So let's get started and see what our agenda is like today. Okay, well, first I'm going to just quickly recap parts 1 and 2. And then we're going to look at new laws that just became effective in 2020. Some of these became as effective as close as October of 2020, this month. Then we're going to look at some proposed legislation that may touch on this topic. And then I want to spend some time giving you some resources, latest news and stories, and making more aware of some of the scams and the exploitation scams that are out there, and in our own communities here, and make you a little bit more aware about those. And then we'll conclude, as always, with an opportunity to ask questions. So let's spend a moment recapping from 1 and 2. So why is this such an important topic? Why is it such a timely topic? Well, our elderly population is growing, and in a society of ever-changing technology, the elderly population is at risk of financial exploitation more than ever. So you have two issues here. We have more elderly people. We have technology that makes scamming and financial exploitation a little bit more easy and more sophisticated and harder to recognize. And you put those two combinations together, and you have what we've seen in the trends of the last few decades. Elderly exploitation is absolutely on the rise. So in parts 1 and 2, we spent a great deal of time looking at what we can do about that. So let's look at some of those statistics real quick before we move in on that. Here you see the trend up the graph there, explosion of population age 65 and over. It's been a pretty steady trend upwards. There was a big jump between 2010 and 2020, and that jump's going to just continue all the way through 2050. Look at the population age 85 and over. It went from being rather minute in the early part of the last century to steadily growing again and having a big jump here in 2010 to 2020. And there you can see the population by age and sex in 2010, and how we have the baby boom era that came into the elderly age group there, started coming in, and that number, as you can imagine, is only growing, and that's what accounts for that big boost you see between 2010 and 2020, and that will continue on. We also, of course, have the added fact that due to medicines and technology and things of that sort and advancements, that people live longer, just generally speaking. And of course, we have here in Florida, where we have a significant elderly population, that there's no reason to believe that's going to stop, that it's not going to continue to be a haven for retirees. And so you put all those factors together, and you can see why this is an important topic, and certainly very recent and on topic for today. So let's look, what are the societal costs of elderly exploitation? Why as a society, even if you're not directly affected, you're not in this age group, you don't have any loved ones maybe in this age group, why should, as society, why do we care so much, and why are we seeing new trends in the law? Well, I've listed a few things here. Financial exploitation causes large economic losses for business, families, elders, government programs, and it increases reliance on public aid. If you may remember, earlier this year we did a whole series on issues with professional guardianships and how they affect elderly and can be detrimental to the elderly in certain cases, especially when professional guardians aren't watched by the court as closely as they should be, and sometimes even personal guardians. And we would see people that were rather financially independent end up on state assistance, on Medicaid. and become, essentially a ward of the state. So even if you don't have someone personally that's maybe subject to this kind of thing, one day you'll be at that age, if all goes well, and two, we all pay taxes, and that would be affected. So we have that societal cost. Also, research indicates that those with cognitive incapacity suffer 100% greater economic losses than those without such incapacities. That meaning the loss is really significant. When we talk about scammers, and we all, whatever your age, you're always dealing with some kind of a gambit of scammers. But when someone's elderly and when they have any kind of incapacity, those losses are tremendous. Maybe what someone who's quoting you an estimate, an unsavory character that would quote to an average age person, middle-aged person, trying to up it a little bit, maybe trying to get a little bit more, it would never up an estimate maybe by 1,000%. What the studies show when it comes to an elderly person, if that same unsavory character wants to take advantage of them, they will up it by that much. It's usually a much more significant loss to this part of the community, those that suffer any kind of cognitive incapacities, and that happens to be something that comes with age. Finally, financial abuse by itself costs older Americans over $2.6 billion annually. I rechecked those numbers, billions annually that are reported, and there's a great number of this that does not go unreported. So when you look at those kind of numbers, you can see why it would have such an effect on society at large. And then when you look at the state of Florida, who has such a significant elderly population, you can see why it's become such an important issue. So let's recap from those parts 1 and 2 so we can segue into what we're going to learn about today. And in those parts, we learned about what are the criminal penalties for financial exploitation. Most of that carries anywhere from a misdemeanor to a felony, and we looked at the details of those. Then we looked at those penalties for civil penalties for financial exploitation. We saw that the person who's victimized and or their guardian or their representative can sue for financial exploitation and recover damages. Sometimes they can recover treble damages, they can recover attorney's fees, punitive damages, things of that sort. So there's pretty tough penalties in place to try to discourage this kind of thing. But then even more importantly, and what's more part of the trend that you're seeing, is holding third parties responsible, imposing duties on them to help protect the elderly population from exploitation when they have an ability to do so. And just, in our last segment, we looked real closely at the expansion of putting a duty to report and prevent and detect on places such as banks, financial advisors, and things of that sort, and medical, and even your medical providers. And we'll look a little bit more at how that's been expanded today in the recent 2020 legislation. So that's our trend. Our trend is from the state of Florida imposing what are pretty tough penalties against financial exploitation, both criminally and civilly, but also trying to expand it and put duties on third parties in the hopes of preventing this and or helping that person recover, the elderly person, the victim, recover in the case that you fail to detect and prevent. So I want to start out too showing a recent study that was done in the last 5 years, and that affects one of our local communities here, called the Villages. Most people are familiar with that. If you're in the Central Florida area, it's one of the largest retirement communities in the country. But FSU, Florida State University, did a study starting in 2015, and they issued their results in 2017. And I just want to give you a few statistics from it and see what they found, so you can kind of again have an idea of what the things the legislature and us as professionals are trying to do here. They found the average age of fraud victims was 72. The average amount lost among the victims was $2,000 per claim. And the most frequent cause of fraud was in-home services, such as quoting unnecessary repairs or exploitive prices for repairs. Now that was at the villages, and this was a study conducted in 2015. The researchers also examined other types of fraud the villages residents were exposed to, and these were the largest categories that they found: misleading sales and advertisements, investment fraud, embezzlement, sweepstakes scams, fraud by health professionals, identity theft, and forgeries. So why are the elderly population, why are they exceptionally vulnerable? We've touched on before that, that there's some cognitive issues as you get older for the average person, and the law recognizes that, and that's why it declares of a certain age the elderly will be protected as a class and deemed subject to exploitation. But the researchers here also found other reasons why the elderly were more particularly vulnerable to these kind of scams, at least in the villages. They cited to critical life events that happened there. Anytime there was a death or incapacitation of a spouse, a significant health diagnosis, and then just having the recent move from another state or from another community. If any of those events happen, which would happen in the course of an average elderly person's life, those psychologically they make a person more weak and more vulnerable and more likely to not question someone who appears to be wanting to help them. And that was a problem they recognized there at the villages. But what I thought was one of the most important things they found was that they found the retirement communities themselves, when a person moves there, that gives a false sense of security, that sometimes the people begin to relax their guard even more because they just presume, because they're in a community surrounded by other like people, that scammers won't make their way to them. People who would exploit them won't make their way into their lives. But that's false. These folks are smart, they're sophisticated, and as we've touched on, they get through to you not just physically, but through the phone, through your computer, through technology, and they're usually very good at what they're doing, and they prey on people not being educated or up to date on whatever issue it is they're addressing, to become dependent on them or feel a need to have them in their lives and doing whatever the event is that's leading to this exploitation. And or the elderly people tend to become less skeptic as they get older. So all those things together come together, and why Florida has a trend now of passing more laws and passing more protections for our elderly population in an effort to protect them and prevent this kind of thing. So let's look at one of the laws that passed just recently. And this one became effective July 1st, 2020, and it's Florida Statute Section 415.1103. And what it does, it provides authority for our Florida state attorneys to initiate an elder abuse fatality review team in his or her judicial circuit to review deaths of elderly persons caused or related to abuse or neglect. And then the state attorney can refer those cases to be reviewed by the team. I did check, it's recently new, obviously, and based on my research, I couldn't find where Orange County or this judicial circuit, the Ninth Circuit, has yet to establish this. But why would you want to have a review team, and how could that maybe prevent elder abuse? Elderly exploitation, you might not think would ever lead to, something like death or be investigated for that. But there have been cases where people are left depressed, left, alone, neglected their health, their nutrition, all those things. So while it might not be the ultimate cause of death, elderly abuse, even financial exploitation, can be one of the causes that led to that untimely death. So not just physical abuse, but I think this is intended financial exploitation and abuse. Any of that's been found to be a factor in the death can lead to these reviews. And here's what happens if you do have that kind of case. The review team, they review the deaths of these elderly persons and within that circuit, which are found to have been caused or related to abuse or neglect. And then they take into consideration the events leading up to a fatal incident, such as available community resources, current laws and policies, and the actions taken by systems or individuals related to the fatal incident. They identify potential gaps, deficiencies, or problems in the delivery of services to elderly persons by public and private agencies, which may be related to the deaths reviewed by the team. They, whenever possible, develop community-wide approaches to address the causes of and contributing factors to the deaths they review. And finally, they develop recommendations of potential changes in laws, rules, and policies to support the care of elderly persons and to prevent elder abuse deaths. So now you can see why the purpose of the board is to examine these deaths, but to try to look and find all the factors and what went wrong and what maybe can be prevented. And I think this is significant when the Florida legislature passes something like this. This board will be made up of persons who are related in that field. It can be made up of a number of different kind of people that may have interest, and those people will serve on a voluntary status. So it's absolutely intended to create good policy, good recommendations, and an awareness of where maybe as society or as a community we may fail or may have, or there may be ways that we didn't realize that we could prevent some of these cases. I think it's a wonderful addition to our laws. I think because it's ever changing and the dynamics are ever changing related to exploitation and abuse, because so much goes unreported, I think it's important that we take advantage for this when we do know something's gone on, and we can look at the circumstances and maybe learn from them. So I'm very encouraged by this this new law and the trend that it supports. So let's look at another law. This one's called the FloridaVulnerable Investor Act, and it's found in section 517.34. So in enacting this law, the Florida legislature recognizes the freedom of specified adults to manage their assets, make investment choices, and spend their funds, and absent reasonable belief of financial exploitation, and that such rights may not be unreasonably infringed. The new law was designed to encourage security dealers, investment advisors, and associated persons to take action to protect specified adults based upon a reasonable belief that a specified adult with an investment account has been, will be, or is the subject of financial exploitation. So what does that mean? That what you're seeing here is that there's new legislation that's been passed that expands that duty to detect, duty to protect. It expands it to financial advisors. You may remember in our last section we talked about banks being specified as a group that must detect and or report, and now we're looking at this being expanded to another group that's related to finances in an elderly with an elderly person. And again, I think it's indicative of the same logic that was used before. Banks are in a position to notice fraud. They actually have programs in their system to look for suspicious activity and fraudulent activity. And if they see that, they need to be not only allowed to report it, but encouraged to report it and required to report it in these cases. And I think what you see here is another attempt to expand that to more folks, third parties that can recognize when elderly exploitation may be going on and can step in and do something. But it also notes that they recognize that elderly folks should have some freedom and to manage their assets and make investment choices. And I think that should show that there's a balancing here of wanting elderly people to be able to make their own financial choices, but only keep an eye and step in when there's some kind of indicia of exploitation or fraud. So let's look a little bit more specifically at this law. Of important note, the new law provides that a dealer or investment advisor may delay a disbursement or transaction of funds or securities from the account of a specified adult or an account for which a specified adult is the beneficiary when certain criteria apply. Let's look at those criteria. The first one is the dealer or investment advisor reasonably believes financial exploitation of the specified adult has occurred, is occurring, has been attempted, or will be attempted in connection with the disbursement or transaction. What's an example? Like in some of the cases I've personally seen or been involved with, if all of a sudden there's complete change of the adults, the elderly person's spending habits, all of a sudden they want to transfer money to not another investment account, not just an account that they use for, to pay certain bills and things like that, or operating account, but all of a sudden some third party that seems, that's never been given anything before, even though this person's been with, your investment firm for many years, they get a large disbursement. And when you ask the person, they can't explain why, they don't have a good reason why. Maybe they're even confused why they did that. Maybe what they tell the financial advisor doesn't seem to make sense and seems to be maybe be an exploitive play. And then maybe you see a few of those kind of transactions, and then that draws your attention. But the standard is reasonably believes has occurred. So that's the first one. Number 2, no later than 3 business days after the date on which the delay was placed, the dealer or investment advisor notifies in writing all parties authorized to transact business for the account and any trusted contact on the account, with the exception of any party the dealer or investment advisor reasonably believes is engaging in, or has attempted to engage in, or will attempt to engage in suspected exploitation of the specified adult, of the hold placed on the transaction and the reason for the delay. So take out, the people that may be contacts or close people to the account holder, taking them out of the picture. The account holder and those other interested parties must get notice of the hold placed on the transaction, the reason for the delay, which would be suspected exploitation, and maybe the specific facts of why there's a suspect of that, and that has to be given within 3 business days. So what's the next term that the advisor has to adhere to if they want to use this mechanism? 3, no later than 3 business days after the date on which the delay was first placed, the dealer or investment advisor notifies the Florida Office of Financial Regulation of the delay electronically and on a form prescribed by rule. So relatively quickly, not only is the account holder going to be notified, so is the Florida Office of Financial Regulation. Let's look at number 4 here. The dealer or investment advisor immediately initiates an internal review of the facts and circumstances that cause the dealer or investment advisor to reasonably believe the financial exploitation of the specified adult has occurred, is occurring, or has been attempted, or will be attempted. So after putting on the hold, making the notifications, then there has to be what they call an internal review of the facts. This is going to include talking to the account holder, talking to the account holder's maybe contact person, trying to ascertain what the purpose was the transaction. Is there a fair consideration being given for the transaction? Or if it's a loan, is the adult that you're concerned about, have they been adequately protected with a promissory note or something else that would make it not exploitation? So those are the things you're going to look into and you're going to document, and then you have complied with this step. So those are the initial steps to put on the hold. Then let's look at what happens. We're going to look at another option you have other than this hold. Second, a delay on a disbursement or transaction under the statute expires 15 business days after the date on which the delay was first placed. So we've looked at what you have to do to get in place, what you have to do within 3 days, but now you have to recognize it's going to expire in 15 business days after the date on which the delay was first placed. So we're looking at a hold here that's just temporary. Except, let's look at the next part. However, the dealer or investment advisor may extend the delay for up to 10 additional business days if the dealers or investment advisors' review of the available facts and circumstances continues to support such dealer or investment advisor's reasonable belief of financial exploitation of the specified adult has occurred, is occurring, or will occur. A dealer or investment advisor that extends the delay must notify the Florida Office of Financial Regulation on a form prescribed by rule no later than 3 business days after the date after the extension becomes applicable. So right now we're looking at a hold that can last up to 15 days, and if after the investigation the investment advisor or dealer is not satisfied that the elderly adult is still not subject to exploitation, they can extend the hold for 10 days more, which would be a total of 25 days. But again, they have to give notice to the Office of Financial Regulation. Third, a dealer or investment advisor must make available to the Florida Office of Financial Regulation, upon request, all records relating to the delay placed by the dealer or investment advisor pursuant to Section 517.34. So you're going to have to be prepared to give up the records that you think support your conclusion here, or and relate to the transaction at issue that you are preventing. Fourth, before placing a delay on a disbursement or transaction, the dealer or investment advisor must have developed and put in place training policies or programs reasonably designed to educate associated persons on issues pertaining to financial exploitation. The dealer or investment advisor must also conduct training for all associated persons at least annually, maintain a written record and transcripts of all training conducted, and develop, maintain, and enforce procedures regarding the manner in which suspected financial exploitations are reviewed internally, and if applicable, the manner in which they are required to be reported to supervisory personnel. If you may remember in our last segment, we talked about banks doing this without even first being directed by the legislature. Most national banks have undertaken to train their employees to spot issues. They have specific policies and a hierarchy of reporting that is supposed to help employees recognize what they should report and recognize what to do. And they try to keep them educated on the most, recent trends in financial exploitation. I think what you see here is a legislative dictate for financial advisors to do the same thing. A dealer or investment advisor who in good faith and exercising reasonable care complies with Section 517.34 that we just reviewed is immune from any administrative or civil liability that might otherwise arise from such a delay in a disbursement or transaction in accordance with this section. So what we have here is an attempt to give immunity, but somewhat qualified. You have to have acted in good faith, and you have to exercise reasonable care. Absent reasonable belief of financial exploitation, the new law does not alter a dealer's, investment advisors, or associated person's obligation to comply with instruments from a client to buy or sell securities, disburse funds, or transfer securities from an account, close an account, or transfer an account to another dealer, investment advisor, or associated person. The new law neither creates new rights nor imposes new obligations on a dealer, investment advisor, or associated person under applicable law. The new law also does not otherwise limit the right of a dealer, investment advisor, or associated person to refuse or place a delay on a disbursement or transaction under other applicable law or under an applicable customer agreement. What that's referring to is that there could be other laws that you suspect being violated, and those laws provide a haven for not taking direction on a transaction, or there may be something in your agreement with the customer that allows you to not approve a certain transaction. So what it's saying is this supplements, this doesn't replace that or affect that, whatever's in place. So what we have here, we have what will be immunity as long as you're acting in good faith and you're exercising reasonable care. Why is that necessary? I think it says it right there. I think most people, scrupulous people would not want to stop a transaction among, family members or something that is needed for the person's health or maintenance. And even if he just wants to go, wants to take a nice, luxurious vacation or shopping spree, those kind of things. I think what's being, trying to be balanced there is someone who wants to control the account and wants to make sure it doesn't maybe get transferred to someone else for handling or investment or things like that. And, keeps them from just saying, hey, you must be losing it if you want to take your money from me. I've been so good to you. So I'm just going to hold and use it as a harassment measure. I think that's what this is trying to prevent. So when people use it, they need to make sure they're acting in good faith. They have no other, reason or motive other than looking out for the exploited person. and they got to exercise some reasonable care. They don't need to extend it another 10 days if there's already been protective action taken or things of that sort, or there's been shown that there's legitimacy in this transaction and things of that sort. So I think it again, like it said sort of in the preamble that we read in the beginning, there's a balancing act here of trying to allow elderly folks themselves to have ultimate control over their transactions, but providing an avenue where if there's a suspected transaction, maybe we can prevent it from going through either through delay or through intervention from the Office of Financial Regulation or other loved ones or interested parties who become aware of the issue. So let's look at the last part under this act that the vulnerable investment rule here. To act under new section 517.34, a dealer or investment advisor must develop training policies, conduct training, and develop, maintain, and enforce written procedures. A securities dealer, investment advisor, or associated person who complies with new section 517.34 in good faith and exercising reasonable care is immune from administrative or civil liability. Again, we're repeating that immunity thing, which is important. No one wants to be sued because they're trying to do the right thing. But with the adoption of section 5.17.34 of the Florida statutes, Florida becomes the 30th state with a law or regulation relating to financial exploitation in this realm with investors and trying to give some kind of protection to investors who may delay or put holds on transactions. So let's look at our next law. Now we've looked at one that's attempting to review. We've already looked at one that took place in July of 2020 that's attempting to establish review boards to try to prevent exploitation and abuse that leads to deaths. We're also now looked at one that attempts to protect elderly persons in their investment accounts. Now let's look at one that became effective October 1st, 2020. This one's commonly called the Florida Veterans Protection Act. It's found in section 775.0844. And what it does basically is the new law enhances sentences, that's criminal sentences, for aggravated white-collar crimes against veterans. In short, it will now be essentially a first-degree felony to obtain or attempt to obtain $50,000 or more from veterans. Okay, we looked before. There's already laws against exploitation of the elderly community, and here they're expanding these laws to make sure they specifically encompass veterans and also to provide tougher penalties, especially criminally, for any kind of criminal activity that targets a number of veterans with large amounts involved. So let's look at what we got going on here. Whoops. Due to the frequency with which victims, particularly elderly victims, are deceived and cheated by criminals who commit nonviolent frauds and swindles, frequently through the use of the internet and other electronic technology, and frequently causing the loss of substantial amounts of property, it is the intent of the legislature to enhance the sanctions imposed for nonviolent frauds and swindles, protect the public's property, and assist in prosecuting white-collar crimes. So this is an enhancement to existing laws here. So as used in this section, I want to make sure you're clear on what some of these terms mean. White-collar crime is the commission of or conspiracy to commit any felony offenses specified in Chapter 560 relating to money transmitters codes, Chapter 812 relating to theft, robbery, and related crimes, Chapter 815 relating to computer-related crimes, Chapter 817 relating to fraudulent practices, and Chapter 825 relating to abuse, neglect, and exploitation of elderly persons. So it is a broad encompassing definition here. I think we all think of white-collar crime as just, computer crime, bank account of crime, embezzlement, that sort of thing. But as you can see, it not only hits those definitions that's used throughout the Florida statutes, but it also any abuse, neglect, and exploitation of elderly persons as defined in Chapter 825. That's what we looked at in the first part of our series here. So that's a pretty broad definition. Oh, there's more. There's Chapter 831 relating to forgery and counterfeiting. There's Chapter 832 relating to the issuance of worthless checks and drafts. There's Chapter 838 relating to bribery and misuse of public office. There's Chapter 839 relating to offenses by public officers and employees. There's Chapter 895 relating to offenses concerning racketeering and illegal debts. There's Chapter 896 relating to offenses related to financial transactions. Again, I think this all is consistent with what we think in common layperson terms as white collar crime. But all those chapters have their own definition or deal with a complete category of crimes, and all of those fall under the definition as it's used in this particular criminal statute. So a felony offense that is committed with intent to defraud or that involves a conspiracy to fraud is also falls under this definition. Another part of the definition of white collar crime: a felony offense that is committed with intent to temporarily or permanently deprive a person of his or her property, or that involves a conspiracy to temporarily or permanently deprive a person of his or her property. And D, a felony offense that involves or results in the commission of fraud or deceit upon a person, or that involves a conspiracy to commit fraud or deceit upon a person. So after we've referenced all those chapters and the crimes that are referenced in those, after we've looked at the pretty broad one that's in Chapter 825, what can constitute elderly exploitation, and now these three that really make it broad, really anything that defrauds people or denies them property or some kind of deceit or intent to commit a fraud on folks, all of that can fall under white collar crime. So we also have a term that's used under the statute called aggravated white collar crime. As used in this section, aggravated white collar crime means engaging in at least two white collar crimes that have the same or similar intents, results, accomplices, victims, or methods of commission, or that are otherwise interrelated by distinguishing characteristics and are not isolated incidents, provided that at least one of such crimes occurred after the effective date of this act, again, which was October of 2020. So they're seeking to punish anybody who's not just maybe taking advantage of one person or an opportunity, sees an opportunity to take advantage of someone, but aggravated white collar crime is looking for people who are targeting a certain group, such as veterans or elderly folks, and are using similar means or committing at least two different crimes, and so that there seems to be a pattern of doing this. So let's see what happens. Any person who commits an aggravated white collar crime as defined in this section, in so doing, either victimizes 10 or more elderly persons, victimizes 10 or more veterans, victimizes 20 or more persons, or victimizes the state of Florida, meaning any state agency, any of the state's political subdivisions, i.e. cities and counties, or any agency of the state's political subdivision, and thereby obtains or attempts to obtain $50,000 or more, commits a felony of the first degree, and it's punishable under the statutes that set forth those punishments. So what does this tell me? This tells me if I was a criminal and I wanted to commit some kind of white collar crime and do it against multiple parties and multiple people, you should not target 10 or more elderly people, 10 or more veterans, or more than 20 people. That's certainly intended to enhance the criminal penalties if you target these kind of groups. And of course, the state of Florida for more than 50,000. Okay, so notwithstanding any other provision of Chapter 921 or any other law, an aggravated white collar crime shall be ranked with the offense severity ranking chart at offense severity level 9. In addition to a sentence otherwise authorized by law, a person convicted of an aggravated white collar crime may pay a fine of $500,000 or double the value of the pecuniary gain or loss, whichever is greater. It's a pretty significant fine, $500,000. So that's the three newest laws that passed that affect the elderly abuse and exploitation kind of genre that we've been looking at. Again, I think it's consistent with the trends that we've been noting all along. I looked to see what the newest proposed legislation is and what may be coming down the pipe later on. And I wanted to focus on one thing. Most of what I'm seeing spoke about, what I'm seeing that's going to be lobbied for in the next legislative section relates to guardianship. And I've hosted a number of seminars on guardianship and some of the issues there. And of course, these last few seminars have been more targeted toward elderly exploitation. But there's always been in the statutes reference to guardians and fiduciaries and things that, because it recognizes that people that are being exploited may need the protections of a guardianship. And so I think it's important to touch on this, and because I think this legislation is meant to fill in some holes and maybe where things are there's gaps in our guardianship law, and trying to make that more of a concise and protective kind of statute. If you may remember from guardianships, that provides for an appointment of a guardian of an elderly person when that person is deemed to be incapacitated, at least in part. The guardian may be limited or plenary, meaning across the board and all rights, and the guardian can be of the person or the property or both. So let's look at what the changes in laws that are being proposed to protect our community from physical and financial exploitation, and let's look at what's been proposed by the Florida Bar's Real Property, Probate, and Trust Law section. Just recently, in the last month or so, that division of the Florida Bar reviewed the guardianship code as it is stated right now in Florida. Notice there hasn't been a significant comprehensive rewrite since 1990. It left a lot of holes in the code that sometimes the courts are having a hard time filling in those gaps, and sometimes it leaves courts and interested parties without the proper guidance on what to do in certain situations. So the goal was to come up with a proposed rewrite, some proposed new law, legislation, and then there's plans in the works to lobby it to the next legislative section. So I want to go through it and show you what's being proposed, what the main bullet points are, and then let's see if we can note maybe some areas now after we've reviewed all this, what's been trending, what's been passing lately, and what's proposed. Let's see if we can note what's been helpful, what areas are being firmed up, and maybe what areas are left not so firmed up. So these are the goals of the rewrite. Bring uniformity and clarification to many of the statutes and ad hoc piecemeal legislation in the last 30 years. Ensure due process for the wards. Protect wards' privacy and it should enhance the confidentiality of the process. And just in case you're not as familiar with guardianship, wards means the incapacitated person that's under the court's protection and has been deemed incapacitated, at least in part. So we have those three goals. We also have wanting to come up with more and establish more comprehensive procedures to determine alternatives to guardianship. This has been a big trend in guardianship law throughout the 50 states pretty much for a while. Some kind of something can be fashioned by the court, some kind of relief, some kind of protection, short of a guardian being appointed, that adequately protects, it's generally encouraged. And in fact, it's required that a guardianship judge look at alternative means to see if they're available in any particular guardianship before appointing a guardian. And sometimes those can be, because someone has a power of attorney or because there's a trust that holds most of the assets. But obviously, sometimes they fall a little short of being completely able to handle all the needs of the ward or protect the ward. And I think the new legislation is hoping to provide hybrids and more discretion and more guidance for the judges to fashion a result that maybe mixes these kind of things. Number 5, make it easier for a professional guardian to resign when no other person's willing to serve. And 6, prevent granny napping. And if you want to look for a full summary of the report, it's down at the bottom there. So more encouraged oversight over professional guardians is what I've noted as missing. I've noted before that I think legislation should be more in touch with making sure judges adhere to their role of supervising guardians, especially professional guardians. And what I'm seeing in these in the bullet points here is that there's not a lot of addition to making sure professional guardians are held accountable. And in fact, there's a stated purpose there to help it make it easier for them to resign when no one else is willing to serve. Well, why would no one else be willing to serve? That's going to happen when they run out of money. So when you put all that together, if anything, I think this might could be construed to help an unscrupulous guardian, professional guardian who maybe has spent all the money, hasn't accounted for this, hadn't planned accordingly for it, and wants to escape the consequences of that by getting out and not having any further responsibility. So those are things I personally would note after looking through these goals here and looking at the summary of the legislation that's there on the screen, the link to it. So I welcome you. If you have any comments to that effect, if you see some things missing or some things that you would like to see included in this, I would welcome you to also speak up and let us know here as part of our conversation, maybe during the questioning part. So let's move on. I'm sorry, I'm moving a little quickly here, but we have one more section I want to hit before we have to stop for questioning. And that's looking at resources, latest news, and stories. I myself stay abreast by looking at certain websites, certain publications, certain resources given out for different national centers, and some of those here in the state of Florida agencies that we've looked at, including the senior team that the Attorney General has put forward to address these kind of issues. I want to give you some other resources here for yourself and maybe for any of those who are advising people that you can look forward to. One of the ones I find very helpful is the National Center on Elder Abuse. It's a national resource center that provides the latest information regarding research, training, best practices, and resources on abuse of older adults and adults with disabilities for professionals and the public. So it's meant to give a resource to probably most of you who would be listening to the seminar. They give statistics, they give you links to reports, they give you checklists, guidance, and dealing with certain issues. And I think that it's a great resource to have. And it's NCEA, and you can Google it and find their website very easily. Then you have the National Center on Law and Elder Rights, NCLER. It's the National Resource Center for the Legal Services and Aging and Disability Networks, focused on the legal rights of older adults. NCLER provides free case consultation assistance for attorneys and professionals seeking more information to help older adults. Again, I think this is something that a professional or maybe someone who's trying to help someone, just a loved one, or anything like that, you can probably find a lot of things here that's helpful. Again, I think they have the checklist as well, like, if look through these, are these things happening? Show it to the person saying, if these are the factors that are happening, this is indicia of a scam. And maybe that will prompt your ability to find a resolution or get the help that you need. I would encourage you to check their websites, contact them, ask them for resources. Both of these national groups are very good at that. So another one is the Florida State Attorney General's website. As I've said before, the Attorney General here has essentially declared war on a lot of elderly exploitation and scams, and their website is very helpful. The Senior Protection Team was established by the Attorney General, and they review complaints and issues and make recommendations. There's the website there, and myfloridalegal.com/senior protection, and there you can find links to file a complaint, to open government, minutes and things like that from things that have happened, that you can see what's been said in the government, resources, things like that. And there's a biennial rule review. There's e-service, there's consumer protection links, and there's an AG opinion link for Attorney General opinions on these kind of issues or other issues that you can look at. Let's see. Those are the three primary resources I use for good information, good statistics, health and things like that. I think through the course of this, we've given a lot of hotlines, numbers, and things of that sort that I would still continue to encourage everybody to use. I'm going to stop for questions just momentarily, but I just wanted to give you, I always like to end these with like giving you some information on the latest scams. And we also try to give these alerts on our website. We update those periodically to, to give just a quick 4 or 5 minute, spill on, oh, here's the latest scam. Here's what people tell you to do to prevent it. But we have two that I think that I'd really like everybody to know. One is pretty timely because of the stimulus checks that were sent out not too long ago, and the anticipated stimulus checks that we hope to receive in the future from the CARES Act. There were reports almost immediately of certain elderly institutions, residential situations, nursing home facilities, anything that handles your Social Security, Medicaid, Medicare, they were seizing the check, especially if it was like Medicaid or you received any kind of public assistance. The argument being that it's a federal benefit and therefore they can seize it and use it because they're providing the care for you. That is false. The stimulus checks were defined as a tax credit. They're not aid in that sense. And if your check was seized by anyone in that kind of a capacity, report it to the Attorney General and your local authorities. Secondly, census time. There's, because of COVID-19, and there's been even more lack of a response to the census than usual. It's reported that more and more individuals are going out, especially now, now that, it's a little bit more safer and protocols have been reduced for COVID-19, and they're knocking on people's door and trying to get the census completed. This will be part of our next scam alert, by the way. But I want to tell you what you need to do to make sure you're speaking to someone who's actually a census worker. Check their badge. All census workers should have a photograph badge from the U.S. Department of Commerce, and it should have their watermark, and it should have an expiration date. If you see anything like that missing, be suspect, and you can call this number to double check. It's 1-800-923-8282. You can use that number to confirm a worker's identity or for any other questions you have related to a home visit. You should know that if you're asked by a census worker for a Social Security number, financial information, credit card number, bank account numbers, that's a scam. Census Bureau workers do not ask for those kind of things. And if you see anything in the mail that asks for census information, make sure the return address is the Census Bureau in Jeffersonville, Indiana. That should be the only official address mail is being returned to, because not only are they stopping at your door, they're also sending you mail that looks like a legitimate census questionnaire. Those are our scam alerts, and with that, I'm going to conclude and thank you for joining us for this 3-part series. Again, here at Forrester Bowman and myself especially, we really try to stay on top of these kind of issues and try to educate our community about elderly exploitation and related laws. I'm going to look and see if we have any questions now, and if we don't, then we'll wrap this up a few minutes early. Okay. Well, with that, then I guess I'll say goodbye to you and thank you again for joining us. Thank you.